Hello, everyone, and welcome to a new episode of the EB-5 Insight podcast. On today's episode, we will discuss topical issues in the EB-5 industry, specifically the upcoming EB-5 minimum investment threshold increase, recent announcements affecting adjustment of status for U.S. investors, and other general implications for EB-5. Our guest today is attorney Joey Barnett, a partner at WR Immigration. Joey has extensive experience representing immigrant investors seeking permanent residency in the U.S., both through regional centers and investment in their own businesses. He currently serves on AILA's EB-5 committee and is a member of the IIUSA editorial board and has earned national recognition as a top 25 immigration attorney for the last 3 years. With that, let's jump right in, and thanks for joining us to break down what EB-5 investors need to know right now. Joey, welcome. Thank you so much for joining us to break down what EB-5 investors need to know right now.
Thank you, Simon. It's a pleasure to be here, and I've listened to this podcast before, so it's fun to be on it. I'm excited to talk.
Appreciate that. Thank you as well. I'd like to just jump right into our questions, if that's all right. And I want to start by discussing the upcoming investment threshold increase, which is set to take place in January. So, with that said, the minimum investment amount is expected to go up with an inflation-based increase in January of 2027. How do you think investors and regional centers should think about timing right now in June of 2026 when an increase is on the horizon?
It's definitely another factor to push investors to file sooner versus later. There's a number of deadlines that are coming up in the EB-5 world. This is one of them. Right now, folks, I think, are a little bit more focused on the September 30, 2026 grandfathering deadline. But certainly it doesn't make any sense to have to pay additional money for the same benefit. And the RIA, the EB-5 Reform and Integrity Act, was very explicit. It says it shall increase on January 1st, 2027. USCIS hasn't indicated to us one way or the other how that's going to be implemented, but presumably that the law requires an additional investment based on that inflation. They're thinking it's going to be over $930K, maybe more, depending on what exactly happens over the next few months. But from my point of view, the thing that most U.S. investors, at least, well, no, really just all EB-5 investors are looking at is like the final action dates. That's something that is more important and pressing to them, and the grandfathering deadline. I think that's, what is more in front of their focus as opposed to this January increase.
Sure. And that, the majority of questions that we're fielding right now as a regional center, and I'm sure you as an immigration attorney are centered around that grandfathering deadline. And there's lots of conversation to be had surrounding that as well, certainly. Right. But, in regards to, the minimum investment threshold adjustment, do you foresee it having any demand on, regional center projects versus direct projects? Do you think that's a factor?
No, I don't think that's going to impact whether people go direct or regional center. I have been doing EB-5 for 15 years. I've had more denials with direct cases than I have with regional center cases, even though I have probably filed 25 to 50 times as many regional center cases as direct. It's just harder to do. So I guess if there's more money invested into the company, you have to show what that money is going to be used for. If the company doesn't need that money for direct EB-5, they could ask, well, is that really at risk for job creation purposes? So it may require folks to rethink their business plan to some extent if they are planning to do direct EB-5. From my point of view, if someone was to file on December 31st and got a receipt notice that says like December 31st, they would be eligible for the benefit based on the current investment amount. Even though the next day the price goes up.
Right.
And then the question is, well, what about partial filing, partial funding? You guys accept that, right? Where someone could be actively in the process of investing.
Sure.
So someone puts in an initial investment at the end of December and then finishes off the rest of the investment in January or something like that. I can see that being a strategy that a number of people do. So there are things that we'll definitely see play out for demand to come before the end of the year, for sure.
Right, right. Well, you mentioned the grandfathering deadline, of course, which is the more pressing sort of deadline. Between that and the minimum increase, from an immigration attorney standpoint, what sort of legal or compliance issues come with that kind of rush of people trying to file before that deadline and then maybe before the minimum investment increase? What sort of things are you saying it's really important that is still done in terms of compliance?
For the most part, I still think there actually is plenty of time to get a case ready to file. If you're working with, very experienced EB-5 attorneys. So I don't think there is too much of a rush, but there will be as we get closer and closer to it. Everyone wants to file as soon as possible. The big key is you need to have a source of funds legal brief that is well documented. I can't tell you how many times I've seen RFEs because they're missing tax documents of the giftor, even though that is explicit in the requirements. I've seen a number of RFEs where they're talking about, not just the asset itself. So let's say you're using a HELOC for partial of the investment and you get the fund for the HELOC. That's not enough. USCIS wants to know how you earn the money to acquire the property that is being used for the HELOC. And so we know it's in their RFEs. We know how to prepare these cases so they get approved. Yeah, there are shortcuts and ways that you can file, but quicker, but expect a request for evidence. I would prefer to prepare a case properly and not get the request for evidence. But as you get closer to the deadline, I think you're going to see more people kind of pushing it towards, I don't want to call it skeleton filings, but filings that are less robust than they may not be, otherwise.
Right. And, I spoke with an attorney recently on this podcast about how there's some increased top-down scrutiny on I-526E filings right now and the importance of a really complete package. I think the phrase he used was approvable upon filing, the importance of that right now, because there's been a little bit of a shift perhaps towards direct noids or even direct denials without RFEs. So, he's certainly seemed to think that top-down scrutiny is really in effect right now as well.
I think to some extent people abused the actively in the process of investing and went too far the other direction and, barely signed a subscription agreement or only invested 10K or 50K or something like that. And USCIS wanted to put an end to that practice. There was a note on the immigration listserv for AILA yesterday that a couple of MTRs on this issue were sustained, and so they're going back to USCIS on this actively in the process of investing issue. So the cases were denied by USCIS. There was an MTR, a motion to reopen, filed or an appeal filed, and then the appellate body agreed with the investor, and now they're sending it back down to the immigration office to approve, or at least to look at it based on these directions. And one of those directions are, yes, you explicitly can be actively in the process of investing, right? And what they were requiring in the denial was beyond what is required in the law. So
Got it.
I do see, we will see more of that pick up as well, actively in the process of investing for sure.
Sure. Well, lastly, just forecasting into the future, how do you expect this 2027 investment threshold increase? How do you expect it to affect investor behavior, in terms of timing, in terms of how they view project selection, maybe in terms of their overall demand? How do you see it affecting the investor overall?
I think a lot of investors know that the time is limited and that they need to act quickly already. This is just more fodder for the fire, so to speak. So I expect investor demand to continue to increase as we get closer to the deadline of September, and then again as we get closer to the end of 2026. And the EB-5 program continues on October 1st. They're still adjudicating cases. People can still file. When or Congress extends the regional center program, and they better, because that's my livelihood. Then all of these folks who filed in October and afterwards are also going to get the immigration benefit. So it's not like the world ends on October 1st. And I think still, even at this point, I think most regional centers are looking at still the September deadline first.
Most definitely. Definitely. I want to shift gears a little bit and discuss some of the recent treatment of adjustment of status from USCIS. So there's some recent USCIS guidance that appears to make adjustment of status feel a little bit less predictable for some applicants. As of now, what can we say has actually changed and what did not change for EB-5 investors filing from within the U.S.?
Nothing has changed. The law hasn't changed. From what we understand, USCIS officers are asking 3 additional questions at adjustment-based interviews, but they generally do not issue adjustment-based interviews for EB-5 investors. They just approve the adjustment.
Right.
So nothing has changed. What they are attempting to do, and this is a Stephen Miller plan written all over it, is they're mischaracterizing what an adjustment of status is under the law and how people use it. And this is not related to EB-5. This is related to all individuals in the United States who are applying for a green card in the United States. So that includes family-based immigration, that includes humanitarian-based immigration, asylum, things like that. There has always been this level of discretion in an adjudication by a USCIS officer. That's always been there. What this memo did, or was trying to do, was heightening what can qualify as a negative discretionary factor. And there's some things in there which do impact EB-5 investors. For example, when you file an adjustment of status in the United States, you can get the EAD and the Advance Parole. I've advised clients, for the most part, you want to maintain your underlying non-immigrant visa status. But if you don't, or you can't, and you have that EAD, you can work without restriction. That's one of the opportunities that you get from doing EB-5. But now this memo appears to say that if you use your EAD, that is considered a negative discretionary factor when looking at your adjustment. That to me is crazy. And is it something that they can look at? I guess. And they always have. It's about maintaining status. That's what they're looking at. When you're using your adjustment of status EAD, you are not maintaining lawful immigrant status or non-immigrant status at that time. You are in a period of stay authorized by the Attorney General. There is a distinction in the law about this. And you're not accruing unlawful presence, but you also don't have lawful status. And I think that's what they're picking on here. I think they're picking on people who enter with a B visa, a visitor visa, and then file an adjustment quickly. I don't think necessarily they're focused on H-1B or F-1 students who are coming in to go to school or who have been on F-1 for years and are now transitioning to green card. That to me doesn't seem like what they're going to be picking on. So no, it's not like someone in the United States cannot file an adjustment of status today, that you can still do that. You will not need to necessarily do consular processing. And you can continue to live your life in the United States while you wait for the conditional green card.
So then do you think it's accurate to say that USCIS is kind of pushing EB-5 investors to file from outside the United States? Or would it be more accurate to say that, AOS is still available, the adjustment of status is still available, but potentially under stricter scrutiny?
For sure, the latter. It's available, but under stricter scrutiny. That's a great way of describing it. It's the same things that we've been talking about in the past. Unauthorized employment is a no-no. Entering with preconceived intent to adjust is a no-no. Like, there's things that you shouldn't do even before this that was sort of low-hanging fruit for USCIS to pick on. I think those are going to be, that's what they're going to be going after.
Right. Well, you kind of touched on this a little bit already, but how should EB-5 investors specifically be thinking about travel, advance parole, and their work authorization if they pursue adjustment of status right now in the current environment?
It's a great question. A lot of my clients are doing this because they are H-1B tech workers and they are worried about their career and they see layoffs in the future and they want a backup plan. And, you can't travel until you have your advance parole. Once you have your advance parole, well, I shouldn't say that. You can travel, but your advance parole would be deemed abandoned. Once you have your advance parole, and this is for H and L visa holders only, then you could use that advance parole to come back in and avoid going to the consulate, which is a big issue because it's hard to get appointments. So a lot of people want that advance parole to travel. When you come in on an advance parole, you're actually coming in as an arriving alien. And that carries a whole host of issues that the Trump administration is pushing for, in terms of including, the discretionary. It's always discretionary to enter on advance parole, but they could potentially detain you without bond. Is the scary part if they classify you as an arriving alien. That's scary for a lot of people. And last summer, people called me paranoid when I brought this up, but I was a little bit nervous because we saw the new administration coming in. We saw them picking up immigration enforcement, and we didn't know where they were going to go. We haven't seen that really play out. And in particular, we haven't seen it play out for EB-5 investors. Like, we're certainly not being targeted or anything like that. But who knows what's coming next? And I think what we have to do is kind of just maintain a conservative posture. And that's why I say maintain your underlying status as long as you possibly can.
Sure. I want to also ask you about something that I've asked each attorney that I've sat down with on these podcasts, which is, about the upcoming grandfathering deadline. We've kind of danced around it a little bit. For someone who's listening now and really trying to plan ahead, what is the single most important thing for them to understand about the grandfathering deadline in September?
The single most important thing to understand, ultimately, I don't think it's going to make much of a difference on your EB-5 case, and I would almost ignore it, is honestly my recommendation. There's still 3 months or more, which is enough time to prepare your case. So for somebody looking and listening today, you can file before September 30th. Yeah, there's things you got to do. You got to find the project. Obviously, you have to have the funds. They have to be liquid, but there's time to do it. And so, it's somewhat of a pressure clock, but it's reasonable and doable.
Sure. And kind of piggybacking off of that, how should an investor balance the desire to file quickly, not necessarily quickly, but ahead of the deadline, if that's what they want to do, that desire against the need to make sure that their source of funds and project documentation is fully ready and really complete?
It makes no sense to file a case that's not going to get approved, in my mind.
Right.
And we've seen in past EB-5 deadlines, there's crazy demand that gets avalanched onto firms, and they're not always able to manage it. And so that's something that is important. You need a group that has the capability and the size to really put your case together and make sure it's done properly. That's why, our firm has 15 people with over 10 years of EB-5 experience. So I think there's going to be plenty of time for us to put that together.
Gotcha. Well, look, thank you very much for your time and in the discussion today and for answering our questions. There's clearly a couple of important dates coming up, the grandfathering deadline, this minimum increase in January, and there's some current scrutiny around adjustment of status as well. But it's really great to talk to you to bring some clarity to our viewers. Do you want to go ahead and let our viewers know, where and how they can find your practice and get in touch with you?
Sure. Yeah, Simon, thank you so much for having me on. And I always look up to Houston EB-5. I feel like you guys are leaders in the EB-5 community, so it's my honor to be here. Thank you so much for having me. For anybody listening, you can reach out to me at jbarnett@wolfsdorf.com. That's a mouthful, but we can probably put some information up, but it's WOLFSDORF.com. So I'm happy to help. You can also just go to WR Immigration or type that into YouTube after you listen to this, and you can see more of our webinars and seminars on yours too.
Absolutely. And we will be sure to plug all of your information with our post as well. And so thank you again for your time and for joining us today on our EB-5 Insight podcast.
All right. Thanks, Simon. Have a good one.
Thank you very much. Have a good one.